Good morning and welcome to the Maryland Public Service Commission. This is a status conference in case number 9667 with respect to the petition of the Office of People's Counsel to investigate the future of First Energy's relationship with Potomac Edison in light of recent events. We'll begin by taking appearances of counsel, beginning with Office of People's Counsel. Mr. Cleaver.
Yes.
There we go. Your awful microphone continues to be awful. But if you could just speak loudly. We can't hear you at all.
Can you hear me now?
Yes, now we can, just barely.
Okay, I'll try to keep my voice up. Good morning, Mr. Chairman, Commissioners. Joseph Cleaver on behalf of the Maryland Office of People's Counsel.
Thank you. Counsel for the utility, Potomac Edison.
Yes, good morning, Your Honor, and Commissioners. Joseph Curran on behalf of Potomac Edison. I'm also joined by my colleague, Christopher Gunderson, as well as I see on screen is our colleague, Mr. Jeffrey Trout, counsel for Potomac Edison.
Thank you. We have counsel for MD Sun. Good morning.
Good morning, Mr. Chairman and Commissioners. Susan Miller on behalf of Maryland Solar United Neighborhoods.
Thank you. Do we have any other counsel that wish to make an appearance today?
Good morning, Your Honor. Good morning. I'm Brian Green. I represent Interstate Gas Supply, DBA, IGS Energy, and also Vistra Corp. My clients filed a petition to intervene out of time on December 3rd. Quite frankly, I wasn't sure, as a not a party to the proceeding at this point in time, whether to enter an appearance, but I figured I would err on the side of doing so.
Thank you, Mr. Green. We'll get to your late file petition in just a moment, but welcome. Good morning, staff counsel.
Good morning. I was bumped off and seem to have been joined twice. So Peter Wilson on behalf of staff, and I'll try to figure this out.
Thank you for speaking quickly, Mr. Wilson.
Mr. Wilson, you're signed in twice. You need to mute the volume on whatever second device you have.
Okay, we'll start with Mr. Green's preliminary matter. He filed.
Excuse me. I apologize. I missed my my opening. Lisa Brennan. Good morning, Commissioners. Chairman, Lisa Brennan on behalf of Montgomery County, Maryland.
Thank you. Good morning, Ms. Brennan. If I could ask all counsel to just remain on camera the entire time. Our screen doesn't show folks that are hiding out without their video on. So I'll make a last call. Any counsel wishing to make an appearance?
Your Honor, I apologize if I could. I'd also like to enter the appearance of Irene Wiggins on behalf of the Maryland Office of People's Counsel this morning.
Thank you. Welcome, Ms. Wiggins. All right, Mr. Green, as just stated, filed a petition to intervene on December 3rd, 2021 on behalf of Interstate Gas Supply Incorporated, doing business as Energy and Vistra Corporation. For good cause, I would propose that the commission grant this motion and make his client a party to this proceeding. Do any commissioners object? Seeing none, Mr. Green, you are now party to this proceeding. So today we scheduled a status conference to see where this request from OPC is moving forward. Since the date and we scheduled this conference, we had two pleadings that were filed earlier this month. The first was Office of People's Counsel's request to reconsider the commission's decision in order 90-033. And then just late yesterday, we received the utilities response to OPC's motion for reconsideration. So the commission will need to dispose of that matter before we move forward with the status conference. Mr. Cleaver or Ms. Wiggins, I will give you an opportunity to respond to the argument that was filed last night by Mr. Coran and Mr. Trout. If you seek to respond, you don't have to. We can't hear you, sir.
We do seek to respond. Thank you for the opportunity. Your Honor, as this commission has now heard repeatedly in various filings from Potomac Edison says that Potomac Edison, has identified approximately $38,000 worth of improperly classified or inadequately documented funds that were passed on to PE ratepayers. And as we've all heard in multiple filings and hearings and so on, this number was the result of an audit performed by Raymond Valdez, an employee of First Energy Services Company. In order number 90033, of course, the commission reversed Commissioner Linton's proposed order compelling Potomac Edison to produce the First Energy investigative report to OPC. In that order, the commission noted that Ms. Eileen Mickelson, a former employee of both First Energy and FESC, provided Mr. Valdez with a list of certain vendor accounts to verify the accuracy of the allocation of funds among its subsidiary utilities. The commission further noted that based upon his analysis of the documents provided, Mr. Valdez determined that Maryland's distribution rates included approximately $38,000 that lacked proper documentation. In a footnote to that passage, the commission noted that Potomac Edison has provided these documents to OPC. The commission also noted that based upon the record, this utility audit, in other words, Mr. Valdez's audit, involved no legal opinions or advice from First Energy and appears to be an entirely accounting-based analysis. The vendor costs attributed to Potomac Edison are facts, and First Energy and the company could have conducted a similar audit at any time. Now, as Your Honor just mentioned, OPC filed a motion for reconsideration of this order. OPC agrees with Commissioner Linton's conclusion, which the commission.
Mr. Cleaver?
Yes.
Mr. Cleaver, I'm going to interrupt. We don't need to rehash Commissioner Linton's proposed order. I'd like you to respond to Potomac Edison's pleading that was just filed last night. I think all the commissioners are well aware of the dispute that's before us.
Sure. Thank you, Your Honor. With its motion for reconsideration, OPC does not challenge the commission's conclusion that OPC is entitled to any documentation upon which Mr. Valdez relied. Nor does OPC challenge the commission's conclusion that, according to the record, the audit involved no legal opinions or advice. In fact, OPC agrees with those conclusions. What OPC believes is incorrect in the order is the statement that OPC has been provided with these documents that Mr. Valdez relied upon. What OPC has and what's been produced in discovery is simply Mr. Valdez's Excel spreadsheet that lists a number of vendor charges that add up to $38,000, and that's it. We don't have any other documents that shed any light whatsoever on Mr. Valdez's audit, the instructions that were provided to him, this quote list, in the words of Potomac Edison, that Ms. Mickelson provided to Mr. Valdez.
Mr. Cleaver,
communications.
If I could interrupt again, it's clear in their 4-page pleading that they stated that they've provided you with everything that is not privileged with respect to the audit and communications between Ms. Mickelson and Mr. Valdez. What is your response to that?
Your Honor, the story set forth in the filing made yesterday is different than what we've heard throughout the pleadings that have been filed in this proceedings. This list that we've heard about, that the commission mentioned in its order based upon Potomac Edison's representation, apparently now there is no list. We've now heard for the first time, this is on page 3 of the response that Potomac Edison filed last evening, that Ms. Mickelson verbally instructed Mr. Valdez as to the audit that he was to perform and the contours and the instructions that Mr. Valdez was to follow. Again, it seems that now the story is there are no documents. In fact, Potomac Edison says, and again, this is at page 3 of the filing made yesterday, there are no other documents in Potomac Edison's possession that reflect any responsive communications between Ms. Mickelson and Mr. Valdez. In discovery, the response was, well, there may be documents, but they're privileged. Now, as I understand this filing that was filed yesterday, what Potomac Edison is saying is that there are no documents. This was a verbal communication and a verbal instruction. Your Honors, the list, in whatever form it exists, and whatever other communications may exist, will help to understand both whether there are additional PE ratepayer funds that should be refunded, and what Potomac Edison needs to do going forward to ensure that Potomac Edison customers are charged only for services provided by FESC that actually relate to the provision of utility services in the state.
Mr. Cleaver, as you just referenced, they're saying there is no list. There's no additional written communications to tender to OPC in satisfaction of your data request. Do we call it a day?
No, Your Honor, we don't call it a day, and for several reasons. One, we've recently become aware of a privilege log that was filed in Ohio that identifies various communications between Ms. Mickelson and Mr. Valdez around the time of the audit that we've heard about, that supposedly led to the $38,000 conclusion that Potomac Edison has represented to this commission. These emails, according to this privilege log, are between Ms. Mickelson, Mr. Valdez, and a number of other employees, all of whom have a firstenergycorp.com email address and none of whom are attorneys, that have been withheld in Ohio and that haven't been produced in Maryland either. We haven't gotten a privilege log here in Maryland, but we've seen a privilege log in Ohio that the utilities, that the Ohio First Energy utilities prepared. It identifies 3 distribution utilities at the top of the privilege log. This is not a First Energy privilege log. That is
Mr. Cleaver, Mr.
Yes.
Cleaver, did you ever, in your discovery, did you ever ask Potomac Edison for a privilege log?
Your Honor, the issue of a privilege log came up at the motions hearing. OPC asked Commissioner Linton to order the production of a privilege log. At the time, Commissioner Linton declined that request. I would note that it's incumbent upon a party asserting a privilege to produce a privilege log. And we have brought this up in the context of this entire dispute as to the need for a privilege log, and we've never seen one.
Okay, thank you, Mr. Cleaver. As I stated at the outset of proceedings that involve discovery, the commission reminds the parties to work together in a cooperative manner to resolve any discovery disputes. Unfortunately, the dispute between OPC and Potomac Edison has now dragged on for months, beginning with a motion to compel. We've had one order from Commissioner Linton. We've had another order from this commission. Commissioner Linton held an extensive 2-hour hearing to attempt to resolve the dispute, which apparently isn't resolved until today. I am concerned with what I read last night, whether it be true or not. And at this point, I'm indifferent to the validity of footnote 1 of Potomac Edison's pleading, basically stating that the parties have not worked together to share information that could have prevented this matter from coming before commission. But Mr. Cleaver, assuming everything that you said is valid and Potomac Edison has been withholding these communications between Ms. Mickelson and Ms. Valdez, the fact of the matter is there seems to be a procedural deficiency in the motion for reconsideration. When a party seeks reconsideration or a hearing of a commission order, it needs to be germane to what that order says. And our order 90033, was with respect to the investigation report. That was data request 1-2. And now today we're we're going back in time with respect to earlier discovery disputes. So how does the commission not dismiss your request outright?
Your Honor, I don't see a procedural deficiency. The commission's decision, as reflected in Order 90033, was based upon certain findings that the commission made in the order, which are not accurate. And specifically, the commission's conclusion that this is an accounting-based audit that does not entail legal advice. These are facts. That comes directly from paragraph 21 of the commission's Order 9033. That's been, Potomac Edison is acting in a manner that's inconsistent with that conclusion of this commission. In Ohio, Potomac Edison is refusing to hand over communications about the audit that don't involve any lawyers. With no lawyers on the correspondence at all. First Energy accounting and rates people. That's documents that are at least in the possession of other First Energy distribution utilities. Potomac Edison says last night at page 3 that the Maryland distribution utility of First Energy, doesn't have it.
Mr. Cleaver.
We know that
Mr.
other
Cleaver,
utilities do. And that's
Cleaver.
inconsistent with what the basis for the commission's finding.
But Mr. Cleaver, your appeal, you asked us to look at the decision with respect to 1-2. We looked at the decision with respect to 1-2. This response isn't related to 1-1. So why I'm having a very hard time not I'm having a very hard time because this is the procedural defect that is referenced in the company's filing. You haven't responded to that.
Your Honor, the information requested in 1-1 and the information requested in 1-2, as Commissioner Linton found, and I understand the chairman's instructions, and I'm not going to rehash that, but these are intertwined investigations. Recognize that Potomac Edison only appealed Commissioner Linton's decision on 1-2. And so I understand that, Your Honor. But this commission, in its order, reversing Commissioner Linton's conclusion on 1-2, made several statements that based its decision on reversing Commissioner Linton's order on 1-2 on what had been produced under 1-1. So this commission's order 9033 links the two requests together. The part of the commission's rationale is you received these documents, i.e. what was asked for under 1-1. We agree with that. We agree you're entitled to them. We agree the accounting exercise that Mr. Valdez performed does not implicate legal advice. And that was part of the rationale for saying you don't get to see what's in 1-2.
Mr. Cleaver, I think attempting to bootstrap that argument onto our decision, at least in my opinion, fails. Let me ask my colleagues if they have additional questions before I call a motion. No. I would move that for the reasons stated with respect to procedural defect that the commission dismissed the motion for reconsideration filed by Office of People's Counsel. The vote begins with Commissioner Herman.
Aye.
Commissioner O'Donnell.
Aye.
Commissioner Richard.
Well, I guess after hearing from OPC, it does sound like there are still some documents that they are concerned about, and given that they're doing their best to try to conduct this investigation into some very scandalous behavior in Ohio, I just feel that PE ought to be more cooperative as their public statements say they are being. So this really causes me concern. So I'm gonna vote no.
I vote aye. The motion to dismiss
Can you?
is approved. Who is speaking? Who was that speaking? Was anybody speaking? I heard.
Sounded like.
Okay, well, the motion is approved. We're going to move on to the body of the status conference at this point. Mr. Cleaver, I'll return to you. Where do we go from here?
I will attempt to refrain from arguing the points set forth in the motion in light of the commission's order of a motion of a moment ago and ruling on the motion. But it really does, the issues that we raised there and Potomac Edison's response filed last evening really do both go to the need for additional commission consideration and investigation of exactly what has happened with respect to Potomac Edison ratepayers funding the activities in Ohio and next steps going forward. Based on that representation that we've discussed, and I won't rehash, Potomac Edison on this issue, issue B set forth in the commission's initial order docketing this case, the issue of quote, whether and to what extent First Energy is using or intends to use any funds from Potomac Edison to pay for the bribes, lobbying costs, legal fees, or any other costs associated with the misconduct by First Energy. Based on the representations that have been discussed this morning, and particularly those made yesterday, Potomac Edison's position is that it doesn't have any documents that concern the audit that Mr. Valdez performed. And Potomac Edison doesn't have any information, discoverable information, relevant to the information, to the audit that Mr. Valdez performed. So when Potomac Edison says to the commission that it has identified $38,000 in improperly allocated charges, that's actually not accurate. What Potomac Edison is saying is that First Energy, again, Mr. Valdez is a First Energy employee. He conducted the audit after instruction. It appeared to have been written at one point, now it's verbal. He conducted this audit at the instruction of First Energy. He's a First Energy employee. Potomac Edison says it doesn't have anything about the audit other than Mr. Valdez's final spreadsheet, which was produced. So that calls into question the representation as to the $38,000. This is a First Energy representation that Potomac Edison has repeated to the commission. In other words, you can't have it both ways. Potomac Edison won't let us understand how the $38,000 figure was arrived at, and not just us, OPC. It won't let the commission understand based on the position they've taken in this case. But at the same time, they want the commission to just move on based on this representation that no one can really vet or understand or shed light on as a result of the position they've taken. That's namely that we're outside of the loop, Potomac Edison. We're outside of the loop. We don't have anything about the audit. We don't know how it happened, and we can't tell you anything about it. That speaks to a bigger concern with respect to Potomac Edison's charges that it passes on to its Maryland ratepayers coming from First Energy Services Company. We haven't seen any indication, and this has just been bolstered by the representations that Potomac Edison has made that we've talked about this morning, that Potomac Edison has instituted any procedures as a result of what happened so that Potomac Edison, not First Energy, Potomac Edison, the Maryland regulated distribution utility, can verify and vet the charges that are passed along to it by First Energy Services Corporation. This is an extreme example. This is a terrible scandal involving criminal conduct that we're all familiar with, that we don't need to rehash. But even in this instance, Potomac Edison is in the dark as to where this money came from, or why this amount of charges, rather, I should say, was identified and needed to be passed on. So OPC believes it's appropriate for this commission to continue to examine and make a decision on the measures that Potomac Edison has in place, or that it should put into place, to make sure that this doesn't happen again. And OPC would like the opportunity to provide a recommendation in that regard, and to set forth these issues in writing that we've talked about this morning as to the need for that consideration. So I would say that's on the first issue, Your Honor.
Okay, there's another issue.
Yes, Your Honor.
Okay, let's proceed to that, and I suspect Potomac Edison is getting ready to provide us with their perspective of the world.
Next issue is issue C, identified in the order that gave rise to this docket. And that is, quote, the extent to which the Icahn agreement may potentially cause the Icahn appointed directors to exercise substantial influence over Potomac Edison, as set forth in PUA section 6105. Your Honors, just for ease of reference and just to kind of put it all out there, on this issue, here are the facts that we know. On March 31st of last year, Potomac Edison's counsel, Mr. Trout, filed a, quote, director appointment and nomination agreement between First Energy and the Icahn Group. And that agreement contains a clause that the Icahn Group will not, quote, exercise or take any action that would constitute exercising substantial influence or control over the company or any of its subsidiaries. As this commission well knows, section 6105 of the Public Utilities article contains nearly identical language. That statute requires prior authorization of a transaction that would allow, quote, a person to acquire directly or indirectly the power to exercise any substantial influence over the policies and actions of an electric company. So the language in the Icahn agreement parrots our statute. Pointing to this clause in his March 31st letter to the PSC, Mr. Trout says, quote, First Energy believes that commission approval of the agreement is not required. Again, First Energy believes that commission approval of the agreement is not required. Yet the letter indicates, consistent with the agreement, that the Icahn designees will not vote until all, quote, required regulatory approvals are obtained. And in discovery, we asked Potomac Edison in this docket, what are the, quote, required regulatory approvals? And the only two regulatory bodies that Potomac Edison identified in its response were FERC and this commission, the Maryland Public Service Commission. As we all know, FERC issued an approval of the acquisition, but as we also all know, that's under a very different standard. As of a discovery response dated November 22nd of just last year, so 2 months ago, the Icahn designees were not yet voting based on the need to acquire the, quote, required regulatory approvals. And this commission's the only regulatory body that hasn't approved this acquisition. So this issue now is squarely before the commission, whether to approve this shareholder agreement. Also through discovery, Your Honors, and this is very interesting, we learned that Potomac Edison takes no position on the rights of this commission to enforce the prohibition against Icahn exercising substantial influence. We asked a question in discovery that actually was based on a question, I'll give full credit, that Commissioner Linton asked at the motions hearing, where he asked the company about the enforcement of the provision. The answer wasn't clear, so following the hearing, we issued a follow-up discovery request, and we asked, who can enforce this provision that these two designees won't exercise substantial influence? Can Potomac Edison? Can the Maryland Commission? Can ratepayers? Who can enforce this prohibition? And Potomac Edison responded that, well, this is an agreement between First Energy and the Icahn Group. And it expressly disclaims providing any rights to third parties. I guess in that response, implied in the third party category would be the commission. And then Potomac Edison said, Potomac Edison is regulated by the commission, and this appears to be a legal issue, and Potomac Edison takes no position on it. So the regulated utility that filed the agreement with you doesn't take a position on who can enforce this key provision that's tied directly to our statute. We believe that we have made, or while we've developed, I should say, a strong prima facie case for substantial influence with respect to this agreement. As we pointed out in our petition, the Icahn Group is a minority shareholder, but with unique and special rights. In relation to other board members or shareholders, the Icahn directors enjoy special powers, including that the board cannot form any new executive committees without approval of both Icahn designees. And also, if any non-executive committees are formed, at least one Icahn designee must be given a seat on the committee. Those are just a few of the unique rights that the Icahn designees enjoy under the agreement. So to summarize, you have an agreement before you. Potomac Edison and First Energy are waiting for your approval. But the party who's before you today, who filed the agreement with you, doesn't take a position on the agreement. That party represented First Energy's position in the letter when it filed it, but doesn't take a position. And the evidence shows that these two designees will enjoy special rights under the agreement and the power to exercise substantial influence. And all of that, Your Honors, cries out for a need for a proceeding under Section 6105, where First Energy and the Icahn Group, the parties who apparently can speak to this agreement and what the terms mean and how the provisions will be enforced, can come before this commission and answer questions and submit to discovery so that the commission can make an informed decision as to whether or not it should issue its approval of this agreement. Again, similar to what we've requested in terms of relief with respect to the payment of charges from First Energy Services Corporation, OPC would ask the commission for the opportunity to reduce these facts and legal conclusions to writing and to make a filing with the commission. Thank you, Your Honors.
Thank you, Mr. Cleaver. I was not expecting the status conference to get into substantive oral argument, but you have provided us with sort of the detailed roadmap of People's Counsel's thinking going forward. Provide an opportunity for any other parties to speak before we turn to the utility. Do any other counsel wish to make any statement?
Your Honor, Peter Wilson, on behalf of staff. Staff has looked at this, and we believe the remaining issues here are certainly surround the $38,000 misallocation and perhaps some other financial matters concerning capital structure, et cetera. But nothing have we concluded that can't be dealt with in the next rate case. So it's staff's belief that we need no further proceedings in this particular case, and that what remains can be dealt with in a future rate case.
Thank you, Mr. Wilson. Anybody else?
Yes, Mr. Chairman. Susan Miller on behalf of Maryland Solar United Neighbors. For just a minute, with the commission's indulgence. I respectfully disagree with Mr. Cleaver that we don't need to mention what led up to this proceeding because it is very, very relevant. As the commission knows, First Energy was involved in a bribery scandal. It was investigated by the FBI. The only reason we know about these misallocations and mispayments and arguably fraudulent payments that came from ratepayers to First Energy is because of that FBI investigation. There is a flaw in the commission's regulatory process in which this would not have been discovered, probably never would have been discovered had it not been for that FBI investigation. And this commission really cannot and should not ignore that. The fact of the matter is, First Energy is not cooperating with anyone anywhere. Just last year, years after the signing of the federal agreement, New Jersey Central Power finally admitted that it too had paid $500,000 in this misappropriation. It took that long to drag it out of them. I don't believe we will ever know how much money is actually involved because the perpetrator is not involved in this investigation. The commission chose not to include First Energy. That's within its right. It only included Potomac Edison, who is ostensibly the victim, but doesn't behave like a victim. And so there's all this information that Potomac Edison can rightly say we don't have, that the commission will never have because the wrong party is not included in the investigation. So I would argue the investigation needs to be expanded to include First Energy, since none of the information that's necessary to determine how this happened and how to prevent it is available to the commission. But beyond that, even if the commission does not want to do that, the commission absolutely has to look at how to prevent this from happening in the future. Because whether it's $38,000, $300,000, or $3 million, the commission will not even know if this occurs in the future unless it sets up some regulatory process or protections in order to prevent this type of behavior by the suppliers of Potomac Edison or First Energy itself. Thank you.
Thank you. Ms. Brennan.
Just one thing, Chairman. Montgomery County's concern is that Potomac Edison's ratepayers aren't harmed by the actions of its parent companies. So we would support whatever proceeding the commission thinks necessary to ensure that that happens. Thank you.
Thank you.
Your Honor, Brian Green for IGS and Vistra. The only thing I'd like to add is that reports and audits continue to come out of Ohio since this case was filed that show misallocations or miscoding of costs that should have been consulting fees to one of the unregulated First Energy affiliates that were coded to the utility. There's another audit that addresses the separation of corporate functions as between all of the FE utilities and FE itself. Those continue to come out. So my clients are in favor of expanding the investigation as has been requested. And to the extent that there should be some sort of written submissions after this, we would agree to work with OPC and others as well on that.
Thank you. At this time, we'll turn to counsel for the utility.
Thank you, Your Honor. We'll be very brief. And we do want to assure the commission that you had ordered a period of 4 months of discovery. Potomac Edison took that obligation very seriously. In fact, just so you know, and to give some context to some of the remarks that you heard earlier, there were over 101 individual data requests of us with multiple subparts. We answered all of those. And there were only limited disputes that unfortunately had to come to the commission for resolution, but that was only 6 of the 102. We estimate that between 700 and 1,000 pages of documents were produced in discovery. So there was a very robust period. In fact, and I say this today, while Mr. Cleaver expressed concerns, he did acknowledge during our recent motions hearing that we worked very cooperatively with them and had very limited disputes that ultimately needed the commission's resolution. So to the extent that there is a perception that there was any recalcitrance on Potomac Edison's part to robustly participate and provide discovery, that's simply not the case. In fact, it was limited to just a few areas. As for the substantive issues before the commission and what to do next, I have to say that we agree with staff regarding how to proceed next. Potomac Edison has indicated that it will be filing a rate case in early 2023, and that would be the appropriate venue for the commission to deal with any of the issues regarding the misallocations of funds that were discovered. And in fact, that discovery did occur and was acknowledged to the commission even prior to the commission opening this investigation. So I can represent that all information through that 4 months of discovery has been provided regarding these misallocated dollars. There is simply no reason, there has been no justification provided after that 4 months, no evidence presented to you today that the analysis that was done and presented to this commission was in any way dilatory or inaccurate. Those dollars were identified through Mr. Valdez's analysis. That information, the underpinnings of that, the spreadsheets were all provided to OPC back in September of this year. And they had an opportunity and did ask follow-up questions on that. So we don't see and agree with staff that there's any need to continue any further discovery or procedure at this point, knowing that the ability of the commission to address these misallocated costs will be in the pending rate case. As for Mr. Cleaver's analysis of why this commission needs to engage in a 6105 proceeding, what he has left out is under 6105, and the commission is well aware of this. This was a statute designed in order for the commission to review acquisitions and acquisitions of Maryland's electric companies. The nomination agreement that was filed with the commission earlier last year in no way is an acquisition of Potomac Edison. And Mr. Cleaver has not presented any evidence that he has discovered over the last 4 months that would in any way contradict this. This was the ability of a settlement of a potential proxy dispute that allowed the Icahn Group to put 2 board members on first the parent company's board. Essentially, there is no acquisition, no transaction under 60105 that would require the commission's review. The Icahn Group, under the statute, does not become an affiliate of Potomac Edison as a result of their nomination agreement that was filed with you all. So there is, in fact, no 6105 rationale for the commission to proceed. In fact, I can report to the 5 of you that since the Icahn agreement went into effect, 2 additional independent board members have been slated and nominated to the to the First Energy Board of Directors, growing the size of the board. So the commission should not be relegated to being essentially what I believe OPC is asking you to do is to become an interviewer of board of director nominees before a utility parent corporation. That is not your role and function, and should not allow this to be the commission to simply try to, or allow OPC to encourage the commission to broaden the scope of 6105 beyond the 4 corners of the statute. And as for the representation that we made, that Mr. Cleaver suggests that we acknowledge that the commission has to engage in a 6105 review in order to allow the Icahn board members to vote. That is inaccurate. Out of respect to the commission, the Icahn board members have not been voting until the conclusion of this proceeding. So it's now been over 6 months and they have not voted pending the outcome of this investigation. So we would encourage the commission to put an end to this. There's no statutory rationale for the commission to engage in any additional review of that agreement and would allow these board members to go forward and vote. Of course, we're here to answer any questions, but again, we would agree with staff's analysis that any further examination of costs or allocations from FirstEnergy to Potomac Edison can be and will be adequately reviewed in the context of an upcoming rate case, and we would encourage you to follow the staff's recommendation here.
Thank you, Mr. Curran. All right, going forward, so the discovery period is officially closed. Mr. Cleaver, you stated that you are going to reduce your arguments and recommendations to writing. How much time do you need? Is 3 weeks sufficient? I can't hear you.
30 days, but if the commission wants me to do it in 3 weeks, I'll do it in 3 weeks.
Let's have your response due on Friday, February 18th, along with any other parties, Ms. Miller, Ms. Brennan, Mr. Green. That would be your date to file, the 18th. Mr. Wolson, if your only argument is that we should take this up in a rate case, staff doesn't need to file that. That's on the record.
Thank you, Your Honor.
And then we'll set 3 weeks from that date, Friday, March 11th, for any responsive pleadings. At that point, the commission will close the record and we'll issue a decision based on what the parties have filed. Any question from council? Okay, thank you everybody for attending today. This status conference is now adjourned.
Thank you.